we can get started.
All right. Well, welcome, Elijah. Welcome, members of the Sentencing Coalition, friends, families, neighbors, and Washingtonians, and people just visiting Washington, maybe one night only. I'm really happy to be here in the space, and I'm really happy that I've been invited to several meetings. I'm the new director here at the Office of Public Defense, and as an attorney, I didn't do a lot of appellate work. And so as I've been coming in this position, I've been learning more and more every day that there are people who are in custody that have to write their own legal motions because they're not entitled to an attorney once they pass an appeal by right. For a personal restraint petition, it seems to me, the more money you have, you can hire an attorney, you get a pro bono attorney, and if you can't do those, you have to do it yourself. And when you're doing it yourself, there are all different levels of ability on how to do that. And so as I was listening to members of the Sentencing Coalition, I thought, wow, if I ever get a chance to get information to folks in the community, because if they have to do them themselves, they might as well have the right information. Well, I don't know when it was, maybe a month and a half ago, maybe 2 months ago, during a meeting, I met Andrew Van Winkle, and he works for Division 3, the Court of Appeals. He is a senior staff attorney there, and he works mainly on personal restraint petitions. And as we were talking, I was like, do you like to speak? Do you like to talk? And he's like, yeah, I would love to. And I was like, well, I have something that I want to invite you to. And it was to meet all of you here tonight. I was able to get a first draft of what Mr. Van Winkle was doing. And then I was like, oh my God, this is a CLE. This is a learned treatise right here. This is great information. And so you'll notice that there are a number of attorneys here tonight that have some association with the Office of Public Defense as contractors. And so I'm thankful that you're welcoming them here tonight as well. This is also a great learning opportunity for some of them because often personal restraint petitions are something either you do pro bono or they're not paid for. And so I'm going to be doing a lot of learning tonight. Now, I see that Kaylani has put something in the chat. Is this going to help families save money? No, it's not, but it's going to give you information. There's a PowerPoint presentation that can go around so that folks, if you have to do it yourselves, that they will. Now, it's probably always better to do something like this with an attorney, and you always have a better chance. Right now, I can't change the world in this way. I can say that I'm trying to do the best I can to work on legislation that maybe would give people the right to one personal to representation on their first personal restraint petition, and also in some other limited areas right now to increase our ability to do that. But I want to thank Andrew for coming here tonight to do this. And so I want to let you know a little bit about Andrew, that outside of his regular job, he's a pro tem commissioner for the family law in Spokane County Superior Court. He's also a member of the Washington State Bar Association's Court Rules and Procedure Committee. And he's a member of the Spokane Regional Behavioral Health Advisory Board. So Andrew spends a lot of time giving back to the community. And also, in addition, in his free time, Andrew's a bagpiper with the Angus Scott Pipe Band. So maybe after 6:30, he might play bagpipes for us. But that's not part of the presentation. So, but without further ado, I'm going to give the floor over to Andrew. Thanks a lot for being here tonight.
Thanks, Larry.
I want to say one other thing. If Gideon is on the line right now, if Gideon could put his email address in the chat, all of the attorneys send an email to Gideon that you were here. We're having this recorded, and we're going to send this information to the Bar Association so that you can get credit, and that so Andrew can get credit as well for teaching us. So thank you very much, Andrew.
Thank you. So the presentation is mostly going to be geared towards a lawyer audience, but if you're not a lawyer, or if you're a lawyer and you have a question, unmute yourself, ask me a question. I won't see it in the chat box once I start my PowerPoint, so don't be afraid to unmute yourself, interrupt me, and ask me a question. I don't care how basic it is or how complex it is. I want to address what you folks want to address. I've got a lot of things that I'm thinking about covering, but at the end of the day, I want to do what's helpful to you folks and answer your questions. So just know that you're welcome to interrupt me. So here we are.
Andrew, now that you said you're welcome to interrupt, what about
Yes.
community members here who do a lot of support for those on the inside trying to process the PRPs themselves? A lot of community folks here. So can we just ask questions? It may not be legal, but it may be through a real experience of trying to work through that process.
Absolutely. It's a real nightmare to do this on your own. And even for lawyers, it's a bit of a nightmare. And so if there's a procedural question that I can answer, but one thing is working for the court, I can't answer questions about specific cases, and I'm not allowed to give legal advice outside the context of this presentation. So if there's a question that I can't answer, it's because the ethics rules prohibit me from answering it, but don't be afraid to ask me the question. I'll let you know if I'm prohibited from answering it, but that's just one of the hard things that we have to work around sometimes. So first off, I have to say, because I'm an employee of the state of Washington, I'm here on my own time. This presentation is my own. The views and opinions are my own, not that of my judges, my bosses, the state of Washington, the Court of Appeals. So just know that I'm speaking here to you in my private capacity, but it's informed by my professional capacity. This presentation, there will be an opportunity to email it out. You're welcome to share it with others. If you want to share it with other people on the inside, this is all public. I would just ask if you share it around, please take my email address off the last slide so I don't get improper contact from people, because I can't have contact with people with pending cases. So that's the only thing that I'd ask. So the things that I want to cover, there's kind of three broad things that I want to cover. And one is just an overview of how appeals and PRPs are processed from the Court of Appeals perspective. So just kind of a little bit of the inside. And then I want to talk about a few of the big procedural pitfalls that we see in PRPs, because one of the things that you'll see as a lawyer, you already know this, the lawyers on here know this, but as community members, you probably have heard or figured out that it's rare that a PRP, a personal restraint petition, gets heard on the merits. A lot of times it doesn't get past procedural phase and it gets dismissed for technical reasons. And they never get their day in court, as it were, on it. And that's really hard. And one of the things that courts can do and encourage to do is to promote access to justice and find ways to better promote and facilitate access to justice. And one of those ways is to do what I'm doing here, and that's getting out to people information on these things so that they can help adapt to it. And then the last thing is I want to talk a little bit about the prison infractions, conditions of confinement. We've had some updates on that, and it's an area that as lawyers, you don't really get an opportunity to learn about. I only learned about it until I came about the Court of Appeals. Before coming to the Court of Appeals, I was a prosecutor over in Chelan County for 5 years. We never dealt with those things. We had a few PRPs that I worked on, but the things that happen to people when they're incarcerated and they don't really have a way of redressing it except through a PRP, most lawyers don't get a chance to learn that area of law. So I want to talk a little bit about that at the end if we've got time, or skip ahead if we need to. So a little bit clearer roadmap here. And give an overview. I want to talk about the statute of limitations that applies to PRPs, the timeline, the deadline for filing it. That's a big issue. I want to talk about exceptions to that deadline. I'll talk about the frivolousness standard and prejudice standards, some pitfalls with submitting evidence, how to get a reference hearing. That's one that mystifies a lot of people and it's not easy to do. And a reference hearing for the non-lawyers is sometimes you file a personal restraint petition and you don't have all the evidence you need. And a reference hearing is a way to get that evidence that you don't have. And it's a really hard chicken egg sort of a problem. After that going on, talk a little bit about youthfulness. We're seeing a lot of movement in our state Supreme Court regarding the laws and the constitutional rights of people who are youthful offenders. And that's really changing. I want to talk a little bit about that. And then prisoners' rights, I want to talk about that. So starting out here, this is more for the non-lawyers, just a little bit of background on appeals. There's a lot going on this slide, but I want to start from how something gets to the Court of Appeals and then gets to the personal restraint petition. And so someone gets charged with a crime, usually in Superior Court. They go to trial and they might get convicted or they might plead guilty. And then once that happens, a judgment and sentence is entered, telling the person what their sentence is. Once the judgment and sentence is entered, that triggers a whole slew of deadlines and rules. And so once that judgment and sentence is entered, the person has 30 days to file a notice of appeal and go to the Court of Appeals. And that triggers what we call a direct appeal. And they get this as a matter of right under our state constitution. Everyone who's convicted of a crime is entitled to an appeal. And if they can't afford a lawyer, they're entitled to a lawyer at public expense, which I want to give a shout out to the state of Washington. Not every state gives people the right to a lawyer on appeal. It's not constitutionally mandated by the federal constitution, but it's mandated by our state constitution. So we're a little bit ahead of the curve. Unfortunately, it's I don't know why we're an outlier on that, given how important it is for people to have a lawyer. But Washington gives a lawyer for direct appeals. So you have your direct appeal, and that's where you get to raise your issues of if there was something that happened down at the trial that went wrong that needs to be fixed, if your plea wasn't knowing and voluntary, anything that would cast doubt on the validity of the judgment, anything that would cast doubt on whether or not a person got a fair trial, if there was something that went wrong, you raise that in your direct appeal. And then the direct appeal, the parties, it's very different from a criminal trial, because in a criminal trial, you have people who testify live, they're sworn in as witnesses. In an appeal, none of that happens. In an appeal, all that we see is the transcript of the trial that happened below at the Superior Court and what the parties write down. We get written briefs. It's very rare that people at the appellate level will appear in person. We never hear testimony. There's never new evidence admitted. The evidence is what it was at the trial. So it's a very confined space. And that's the direct appeal, which you get as a matter of right.
So I got a question, Andrew.
Yes.
What if your attorney doesn't add something that you think was important at the trial? Can you add it in your appeal?
So if your lawyer doesn't add something that's important to you, I'm going to put my cursor here and kind of circle around it. The statement of additional grounds for review. As an incarcerated person on direct appeal, you have the right to file your own brief in support of your own issues. And so if your lawyer isn't representing you how you want, because you don't always get to choose who your lawyer is, you have this opportunity to file the statement of additional grounds for review. And one of the things that has to happen is your lawyer is required to help facilitate the filing of that document. So the transcripts from your trial, your lawyer has to send those to you to help you facilitate filing that. The prisons, when you're working on that, they're supposed to give you additional access to the law library and resources. In practice, I know that does not always happen, and that's an issue that we sometimes see on personal restraint petitions, but the prisons are supposed to help facilitate that. And that's an issue for, I guess, your coalition at some point to help work on that.
I have a follow-up question.
Yes.
In the one at the judgment and sentence, you shared that you're supposed to receive this piece of paper that tells you about your right to appeal, 30 days, what have you.
Mhm.
What if you did not receive that? One of our discussions here is around time bar. I think that piece of paper you're referencing is probably part of that time bar to let you know what your time limits are. But that came into law, what, the late 80s or 90s. What if you did not receive that? Do you have a right to go back and be resentenced?
So if a person didn't receive their advice of rights on appeal or tell them that they had the right to appeal, or in many instances, they were misadvised of their right to appeal, what we do is we look at tolling that 30-day deadline. So you don't get resentenced if you didn't get the advice of rights on appeal, but you do get a belated appeal. And I can tell you at Division III, we get several of these a year. And this is one of those black eyes for Washington State for decades. Washington's judgment and sentence form and guilty plea form had incorrect information on appeal rights. And so people who pleaded guilty, oftentimes they were told that they had no access to an appeal, when in fact they do have a right to appeal even if they plead guilty. And so a few times a year, we get people who attempt to appeal a judgment and sentence where they were given the wrong advice of rights or no advice of rights. And sometimes those cases are decades old. And we will send them to our court commissioner. Our court commissioner will hear whether or not there was an error. And if they did not get their advice of rights on appeal, or they were affirmatively misadvised, we do toll that statute of that deadline, and we do let them have a belated appeal, even decades later. We get a couple of these every year. So that's the remedy if they got the wrong information. Those forms have largely been fixed. It's been a while from a new case that I've seen the wrong forms, but the wrong forms still get tossed around sometimes, unfortunately.
Hey, there's one more question that I see in the chat. It says that this person is a new lawyer, and if they want to assist folks with the initial filing, would it be possible to do that and then later have a different lawyer appointed by the court?
Absolutely. If a lawyer just for pro bono hours wants to help people shepherd them through this filing process, but it doesn't want to stay on, or if they get entitled to a lawyer at public expense later on down the road, they can do that. I'd encourage you to talk to the WSBA's ethics hotline about when it's appropriate to file a notice of a limited notice of appearance in a case, as opposed to a general notice of appearance. But the ethics hotline could get someone well advised on how to do a limited notice of appearance to help shepherd people through this. So once the briefs are filed, and if the appellant wants to file a statement of additional grounds for review, the court will take the case under advisement. If you're at the state Supreme Court, you always get oral argument. If you're at the Court of Appeals, you don't always get oral argument. And then after a period of time, the court will issue an opinion deciding the case, and that triggers a whole nother set of deadlines. Deadline to file a motion for reconsider. It triggers the deadline for filing a petition for review to go to the state Supreme Court. And then eventually there's a document filed called a mandate. And a mandate is filed whenever the appeal has become what we call final. So after the opinion's been filed and all motions for reconsideration and petitions for review have been resolved, if the Supreme Court grants review after the Supreme Court has resolved review, 30 days after that last date is when the mandate gets filed. It gets filed in the Court of Appeals, and that mandate triggers the deadline for filing a personal restraint petition. And I'm going to go really in depth onto that timeline for filing the personal restraint petition in a few more slides. But I want to transition now to talking about, from a direct appeal to explaining what a personal restraint petition is. So personal restraint petition, PRP, what it is it's a set of procedural rights that are codified in two different places. You find them first in the court rules, the Rules of Appellate Procedure, Title 16. That's where a lot of the authority exists for personal restraint petitions. And then also there's a few statutes that you see here on the slide that govern personal restraint petitions. And so when we talk about a personal restraint petition, we're talking about cases filed under these two authorities. Going back in time, doing a brief history lesson here, a personal restraint petition is the modern version of what the Old English courts called writs of audita querela and habeas corpus ad subjiciendum. Audita querela, excuse me, my Latin is horrible, and habeas corpus both date back to the 1300s Audita que rela, they think, is from the 1300s. Habeas corpus, they know, is definitely from the 1200s. So we're talking about rights that have existed for almost 1,000 years in our legal system here. These aren't new. Audita que rela doesn't exist anymore in American law. Audita que rela now is what we call, for lawyers, CR 60. Civil Rule 60 for vacating a judgment is the modern version of audita que rela. And if you actually look at CR 60, it even references audita que rela and says that it's abolished and has been superseded by CR 60. And habeas corpus ad subjiciendum. That is what we call the Great Writ. It's the writ enshrined in the US Constitution. And that's the right, when we talk about habeas corpus, that everyone talks about it, asking under what authority it is that a person is being incarcerated. There are other types of writs of habeas corpus. There's writs of habeas corpus to transfer a person from one court to another, to testify at a hearing. We're not talking about any of those today. What we're talking about is this one, the Great Writ, the one that everyone knows of and thinks of. And this one, both of these are the precursors to personal restraint petitions. And so during the common law, or at the common law, these were very limited rights. Original habeas corpus ad subjiciendum, all that it was asking whether or not a person had had a trial and whether or not a judgment had been entered. If a person had had a trial and there was a judgment entered, that was it. That was the end of the review. It didn't matter. We never asked if it was a fair trial. We never asked if the jurors were obviously biased. We never asked if the judgment had been valid. We just checked that there's a judgment, a physical judgment, and that they've actually had a trial. And in the last 800 years, we've expanded on this a lot. As you'll see here later this evening, these rights have been greatly expanded. And frankly, to the better, because originally these were, I mean, they were very progressive at the time, but I mean, by today's standards, they make a mockery of justice. And so what we did here in the state of Washington is we took these old writs that were very complicated and outdated, and we superseded them, and we said, we're getting rid of these old writs, and we've got this new procedure called a personal restraint petition that merges them. And it's supposed to be a streamline, it's supposed to combine them. And that's what we're talking about today, is we're talking about something that has roots going back 800 years, but has been slowly expanding and growing as our notions of justice have expanded and grown over the last 800 years. And as we've realized that a lot of errors happen and a lot of injustice happens procedurally, and we've been expanding it to incorporate that. So what would you find? Yes.
I had another question. What if an individual takes a plea deal to avoid a trial? Do these same rules apply?
Yeah, so if someone takes a plea deal, they can still file a personal restraint petition, but the claims that they can raise are limited. If they took a plea deal to avoid a trial, they can't raise any claims of innocence or sufficiency of the evidence except in one instance. The only time that they can raise claims as to their innocence is if they can prove actual innocence, which our state Supreme Court has left open the idea that a person could have a claim of actual innocence that bypasses all these rules and will be heard. But to date, they haven't come across one. So the possibility exists, but if you take a plea deal, the claims that can be raised are very limited to whether or not the plea was knowing and voluntary, and whether or not the judge followed the sentencing law, whether or not the prosecutor followed the plea bargain, and whether or not your lawyer accurately advised you of the consequences of pleading guilty. Those are the only things that you can raise when filing a personal restraint petition challenging a plea agreement. So when would you file a PRP? Well, the first thing is to submit evidence outside the record on appeal. I mentioned a few slides ago when talking about appeal that the record was very limited to what had happened at the Superior Court. A lot of people will learn things after the trial is over. They might learn from another juror, might come forward and say, so-and-so is looking up Wikipedia on their phone or looking up things that they weren't supposed to on their phone. And that would be juror misconduct. And if there's juror misconduct, that could cast doubt on the integrity of that conviction. But on a direct appeal, you normally can't introduce that evidence. That's new evidence that wasn't in the record. And so to introduce that new evidence, people are encouraged and have this right to file a personal restraint petition. So that's a big reason to file a personal restraint petition. Same thing to develop a claim of ineffective assistance of counsel. If your lawyer didn't represent you accurately, it's probably not going to be apparent for the record. The person's probably going to need to put in information about what their lawyer told them, which means that they're going to have to introduce new evidence. So that's another reason to file a personal restraint petition. If there's been a change in the law, like I mentioned, that we've seen a big change in the constitutional rights of youthful offenders, to receive the benefit of a change in the law after your case is over, even decades later, you'd file a personal restraint petition. And then also, when you're looking for relief from a decision that you haven't otherwise had a chance to put in front of a judge. So if you're incarcerated and you get disciplined, personal restraint petition. If you have a prison-based drug offender sentencing alternative and it gets revoked by a DOC employee and not a judge, personal restraint petition. If the county jail or DOC is miscalculating your earned early release date, personal restraint petition. If the DOC or the Indeterminate Sentence Review Board is jerking you around on your community custody conditions, personal restraint petition. Conditions of confinement while you're in prison, personal restraint petition. Those are all reasons to file personal restraint petitions, all things that we see on a fairly regular basis at the Court of Appeals. But there's sometimes where a personal restraint petition is not the right way to go. So when the petitioner has other avenues for relief, the rules of appellate procedure say that you can't have a personal restraint petition. A personal restraint petition is, in general, a last-ditch effort. It's your last remedy. So if you have any other way that you can get to where you need to go, you can't file a personal restraint petition. So a person who's being held pre-trial in county jail and they don't like the bail that's been imposed, or the judge, they tried to suppress evidence and the judge disagreed with them and they think the judge screwed it up. They think the judge has violated their speedy trial or time for trial. None of those are basis for a personal restraint petition because the person can file a notice of appeal at some point. All of those things have been things that have been determined can wait until the person goes up on appeal. On bail decisions, you normally can't wait until an appeal is filed because otherwise the issue is no longer important. There you'd file a petition for discretionary review, and petitions for discretionary review are kind of outside the scope of this presentation, but bail decisions, we've had a few of those where we've accepted for discretionary review in the last few years. So it's not impossible, but it is hard. If someone owes court fees and they want to reduce their court fees or get those zeroed out, there's statutes in place to do that at the Superior Court level. And so that's not a reason for a personal restraint petition. Off the top of my head, I can tell you in re personal restraint of Flippo, state Supreme Court decision from about 8-9 years ago, so that's not a basis.
Hey, Andrew,
yes.
how about could an individual file a PRP for a DOC prohibited contact order? I just read the question verbatim.
It depends upon the type of order. I think potentially, yes. I have not seen that come up, but off the top of my head, I don't know any reason why it wouldn't be something that could be done through a personal restraint petition. Because the big thing is if DOC does something and you have no other way of getting in front of a judge, an elected judge, a personal restraint petition. So that's kind of the guiding light there.
Thank you.
One of the things that we see sometimes is if you're in prison on a case and you have other pending charges in another county, or you've got a warrant out in another county, like for a probation violation, that impacts your risk classification status in DOC. It affects the jobs that you're offered while you're in prison. It affects what prison you go to sometimes. And so people sometimes if they have other pending charges and they're sent to prison, they want to resolve those so that they can get a better classification, get a better job. It affects their early release, what they can, if they can even be released, to transitional release. And so they'll try and resolve those through a PRP. And unfortunately, you can't do that. If you want to resolve those, you have to go to the county where it's pending, and there's statutes and for doing that, and you can't do that with a PRP. So it's really complicated, but that's one thing that we see sometimes where we just dismiss them because they have other remedies available, and a PRP is not the right remedy. Sometimes if a person is not under restraint, that'd be a reason not to file a personal restraint petition, because they have to be under restraint. And what I mean by restraint is they have to be affected some way by the judgment and sentence. So if a person wants to be resentenced, but they've already finished serving their sentence, they're not under restraint. But if someone wants to vacate their conviction because there's a problem with their conviction, they're still under restraint, because the fact that that conviction even exists is always a form of restraint. You know, that box is always there to be checked on an employment form or a rental form, even if the law prohibits it on those forms. We all know how often people update their forms to comply with the law.
One more, I think this is one more question. And this says, since DOC has quasi judicial powers, they have to, I think it says they have to follow the same rules, right?
So DOC, the rules that they have to follow come from two sources. One, the Due Process Clause of the 14th Amendment to the United States Constitution. And there's a lot of Supreme Court precedent, federal Supreme Court precedent and state Supreme Court precedent explaining what due process means for prisoners. That's where a lot of the rules come from that they have to follow. And then number two, the Washington State Administrative Code prescribes a lot of the rules that they have to follow. And if we start running low on time and people want me to get to that, I've got slides on that at the end. So you just tell me when to skip ahead if you want me to get to that later. So those are the reasons not to file a PRP. One of the things Larry asked me to do is to talk about the PRP form and show that. So I'll do that right now. You can find it online. These are links to the form, and I'm going to pull that up right now. And so this is the personal restraint petition form. So if someone wants to file this, they've got a form that they just need to fill in the blanks. When I was looking at the form this afternoon, I realized that AOC, the Administrative Office of the Courts, they recently updated the form to comply with new RAP 18.17. And in doing so, whoever at AOC updated it, they really botched it. The formatting is no longer right. The formatting used to line up really nicely with this form, and it just doesn't anymore. And I'm hoping AOC will go back and fix that. I don't know who at AOC to contact about it. If I did, I would do it, but it's their new form that they put out recently is not good here. So actually getting to it, the form has a few requirements, and all these requirements from the court rules are here in the form. Person has to state their status, who they are, where they're serving their sentence, where they were sentenced at, what their crimes were, whether they went to trial, whether they pleaded guilty, who their lawyer was.
I think you're showing us the form.
I think so. Am I not?
No, you're showing us it says, where can I find a form? And then it's got the two things.
I'm going to start the screen share over again, and that should fix it.
Okay.
Did that fix it?
Yeah, it did.
Okay. So there's a lot of questions here, yes, no questions that are just background ones that help the court get their bearings and figure out where this case fits within the procedural laws. If a person doesn't know the answers to all these questions, that's okay. The court will say that if there's a defect in the petition, what we do in the formatting of the petition, so if they miss an important question, or if they don't have all the formatting correctly, we'll let them know and we'll give them an opportunity to correct it, and we'll tell them what needs to be corrected. What we don't do, though, is if a person's legal argument is deficient, they don't cite case law, we don't tell them that they need to go back and do that. The court rule only has us give it back to them if there's a formatting error or if they miss one of these yes, no sort of questions. asked people to answer whether or not they've asked for collateral relief. Otherwise, I can tell you right now, a lot of people, they don't necessarily always know how many PRPs they've filed or where they filed them. The Court of Appeals knows. We have them. Here on site at Division 3, we have hard copies of every single PRP order that has been issued at Division 3 going back 20 some years. And there's hard copies with the Washington State Archives going back further. Every single PRP order that has ever been issued is saved unless it was lost in the state archives as flood about a decade ago, but I'm not aware of any PRPs being lost in that flood. And then once you get through those preliminary questions, the form has you talk about what your grounds for relief are, what you're asking. And the form is intended to be supplemented by other sheets of paper. So it's intended that people will attach additional sheets, but it's supposed to give them the idea of how to lay out their argument in a logical manner that will help them get solved. And so questions of what are they asking for? What are their grounds? What are their reasons? And then after that, you get to what's really important here. I shouldn't say what's really important, but the thing that's really important for people to know is the statement of finances. There's a filing fee associated with the personal restraint petition, just like all court pleadings. And if a person is indigent and can't pay for it, like most everyone in prison, they're entitled to file the PRP for free without having to pay the filing fee, but they have to fill this portion out, this section C, they have to fill this out before we're allowed to waive the filing fee. Now, I can tell you from experience, if a person doesn't fill out their statement of finances, we'll do one of two things. The first thing that we'll do is we'll check and see if they had another recent case at the Court of Appeals. If they've had another recent case at the Court of Appeals, usually within the last 2 years, we'll see if there was a statement of finances and an order of indigency in that case. If there is, we will continue to presume that the person is indigent and will waive the filing fee. If a person doesn't have a recent statement of finances and order of indigency on file with us from the last couple of years, we'll put the petition in a stay status and we'll tell them that they need to file this. And then whenever they get this back to us, we'll unstay it and then we'll proceed with it. But it can take a while. It takes people sometimes months to get this back to us. And all that time, their case isn't being heard or looked at. The court does not look at these until the filing fee, until the statement of finances has been filed. I will say that we've made an exception for Blake. If a person doesn't file the statement of finances and they're asking for Blake relief, we've been trying to streamline that. But outside of that, it'll hold up your PRP for months and months and months. These are all statement of finances questions. And then finally, the court wants to know, what are you asking for? Are you asking for new sentencing? Are you asking for a new trial? Are you asking that the case be outright dismissed and expunged? And then lastly, the person needs to sign their oath of petitioner, sign under penalty that it's theirs, duly subscribed and sworn, that they've examined this petition and to the best of their knowledge is true and correct. It has to be notarized, but if a notary is not available, they just have to say a notary is not available, which for the most part in the prison, the notary is not available. Or if the notary is available, the notary charges a fee and they can't afford the notary's fee and they just say that they can't afford the notary's fee. And then they have to sign it. Sometimes people don't sign their petition and we'll send it back for them to sign it and that can hold it up for months. So that's the personal restraint petition form in a nutshell and what the contents are in a nutshell.
I've got a question for you.
Mm-hmm.
What's the difference, or is there a difference between a PRP and a 7.8 motion? Are they the same thing? Is that just what the court rule is for a PRP, or are they different?
So there's a difference and not a difference. So this is really weird. This is really weird. So Washington, I'm going to take you back to the 1970s here. So Washington, before we had PRPs, we had habeas corpus. And then habeas corpus was really cumbersome. And so back in, I think it was 76, we created criminal rule 7.7. 7.7 looked a lot like current rap title 16. And we had that for 2 years. And the trial courts were overloaded. The trial courts were way too busy. Court of Appeals had some extra room. So they repealed 7.7. They created RAP Title 16, which is our current PRP procedure. That was, I think, 1978. A couple years later, PRPs were slow at the Court of Appeals sometimes. We're a lot faster than the superior courts these days. And people started filing CR 60 motions in criminal cases. And I told you that CR 60 is the modern day version of the writ of audita querela, which was used sometimes to give people relief from criminal convictions. So CR 60, which is a civil rule, not a criminal rule, people started filing these motions. Our state Supreme Court, after a few years, I think it was 1984, our state Supreme Court stepped in and said, you know what, we're going to extend CR 60 to criminal cases. So you can file a CR 60 motion in Superior Court. You don't have to do a PRP. A PRP is not your exclusive means of relief. A few years later, Seth Dawson, the former Snohomish County prosecutor, filed a request to formalize that procedure. Seth said, okay, CR 60 now applies to criminal cases. Can we formalize that? And the state Supreme Court said, Seth, okay, we like your rule. We're going to make some tweaks. And they created CRR 7.8. So CRR 7.8 exists in tandem with personal restraint petitions. And so a lot of the rules that apply to personal restraint petitions apply to 7.8 motions, but not all of them. And again, the Superior Court started getting bogged down, and it started being hard for the Superior Courts. And so they created in 2007, our state Supreme Court dialed back 7.8 motions, really locked down the transfer procedure. And so we're now at the point where most 7.8 motions are required to be transferred to the Court of Appeals and converted into personal restraint petitions. So they work in tandem with each other. It used to be that personal 7.8 motions would get transferred to the Court of Appeals in the interest of justice. Now it's mandatory a lot of times. And I can tell you 7.8 motions, I would really encourage people not to use that unless they've got a Blake issue or a PRP of Monchke issue where it's really obvious that they're entitled to relief. And here's why. Our state Superior Court judges do not receive training on post-conviction relief. They don't know the standards. They are frankly clueless on it. 2, with COVID, they are so backlogged on civil and criminal cases that these will just sit in their inbox. Unless a petitioner knows how to file a hearing notice and note a case up for hearing, which they usually don't, it's never going to get heard, or it's going to get heard months and months and months later. I can tell you from experience, we have an extreme egregious instances, and we're talking pre-COVID here, 7.8 motions have sat in a judge's inbox for a year, a full year in the inbox, in chambers, nothing happens. And so that's why I say, don't file a 7.8 motion. You're at the Court of Appeals. If you file a PRP, someone is looking at your PRP, usually within a few days of it being filed, if not the same day. So if you're looking for sure and effective and fast relief, the Superior Court is not the way to do it. The Superior Court judges, they just don't know. I can tell you Spokane County is trying to get better about this. Recently, Spokane County, they reached out and they asked if we could give them some materials for 7.8 motions. And so for Spokane County, I created some new forms for them, and I created a bench card for them that they're just now rolling out to help the judges understand how to do 7.8 motions. So Spokane County has actually been a little proactive on this recently. They now have a bench card, they now have new forms, but there's still a big learning curve. And so if other counties reach out, we're happy to help them with it, but they just don't have the knowledge for this. And it's just not, I think you're spinning your wheels if you file a 7.8 motion. That's my own personal opinion. So how does a PRP differ from an appeal? So a little bit more here, the direct appeal is not an original action, meaning that the record is limited to what was filed down below. A PRP is considered an original action, which means that the record is built from the ground up. The record is whatever the petitioner attaches to it. In an appeal, most of the rules of appellate procedure apply. In a personal restraint petition, only some of the rules of appellate procedure apply. If you take a look at RAP 16.17 and 16.15, that'll tell you what rules apply. On appeal, you have a right to indigent counsel. In a PRP, you only have a limited right to indigent counsel. It's not across the board. In appeal, you have 30 days to file. PRP, you have 1 year to file, and I'll talk more about that time bar. In appeal, you don't have a right to discovery, meaning you don't have a right to expand the record. In a PRP, there's some right to discovery, but it's very limited. It's anticipated that when you file your personal restraint petition, you'll have all of your ducks in a row and you'll have all of your evidence available to you then. And if you don't have all of your evidence available, there's sometimes the ability to get that evidence, but it's hard. And then it's a little bit of a seesaw here with the appeal. With an appeal, there's strict error preservation standards, and error preservation standards, if you're a non-lawyer and you don't know what I'm talking about, that's okay. We don't really want to get into that. For a PRP, we can review unpreserved errors that wouldn't be reviewable on appeal, but there's a trade-off. On an appeal, we have generous prejudice standards, such as constitutional harmless error, structural error. In a PRP, there's very strict prejudice standards, and in the PRP across the board, the burden is on the petitioner to show that they were prejudiced by the error. On an appeal, the burden is sometimes on the state to show that the defendant was not prejudiced by the error. So that's the trade-off. In a PRP, you get to review things that you can't raise on appeal or weren't preserved for appeal, but it comes with the trade-off that you have to show prejudice. So
I got a question. Well, there's two questions. One just came in the chat. Let me see. One that from the chat, it says if public defenders are not offering this information from the beginning of an individual case, then an individual will never know what's been shared today. Public defenders should be sharing this information.
Absolutely. So public defenders, they are ethically required to advise their clients that they have the right to a collateral attack, but that ethical obligation is a pretty low bar. They just have to tell them that they have a right to a collateral attack, but they don't have to advise them. And an argument can be made that they're prohibited from advising them about all these little rules and about how these things are different. And so the only way for them to get this information is if it's out there online, if there's guides on the internet, if they happen to find the right person or they happen to get the right lawyer who gives them this information. Otherwise, there's just no way of knowing. One of the things that, for me as someone who wants people to have access to justice, that frustrates me is that there's this big disconnect on how to get this information without hiring a lawyer. Outside of this, if you go to any superior court in the state, at least in the big counties, I don't know about the small counties, all the big counties, they have what are called family law facilitators. These are non-lawyers who work for the judges who help facilitate the filing of protection orders. They give people all the forms they need to file protection orders, or to file divorces, or to file for changes in their parenting plan, or to file for guardianships. They give these people the forms. They help them fill out the forms. They help them serve the forms. And these are people, non-lawyers, who work for judges. It's not considered the practice of law, who at least get them pointed in the right direction. I don't know why we don't have PRP facilitators in the prison. If there's one thing where we could put money, I mean, if we're not going to provide lawyers for people to do PRPs, we could at least do it that the prisons could hire non-lawyer PRP facilitators and station them in the prisons, just like we do with family law facilitators. I think that would be the best way to get this information out to people, but that requires a legislative fix. I work for the courts, not them. So food for thought for your group. If you're going to do something, a PRP facilitator modeled off of family law facilitators.
And I have one other question about PRPs themselves. You said that there's no right to discovery. And if there's no right to discovery, how do people get new information in that PRP to get in front of the court?
So the way that they get that information is they're expected to be their own detective and do their own digging and do their own legwork. So let's say that, well, the first thing that they normally do, if you're filing a PRP, the first thing that you need to do is you need to ask for your client file from your former lawyer. You need to get a copy of your discovery if you don't already have it. Once you have your client file, hopefully it's intact. Larry, I'm actually going to follow up with you offline later because on the Court Rules and Procedures Committee, I'm talking about sponsoring a court rule for helping people get access to their client file because it's really hard. So I'm just let you know, I'm going to follow up with you on that. So you need to get access to your client file. Once you do that, you can try and figure out who your lawyer might have failed to interview. If there's a witness that your lawyer missed, something that your lawyer missed there. And then you can try and reach out to that person and try and get information from them. That means sending letters. More often than not, it means having a very dedicated family member on the outside who's willing to be that advocate for you and do that legwork. Sometimes your lawyer is willing to do that for you pro bono if they feel that you really have a case, and hats off to those lawyers who do that, but sometimes they're able to do that and are willing to do that pro bono. Once you do that, sometimes you'll find out, you'll discover new evidence. There might be a change in DNA testing technology. You might find out that there is a piece of evidence that was never tested. It was submitted to the crime lab, but they didn't test it. You could pay for private testing, or you could potentially file a motion asking for testing. And that would be something that you would ask for in your PRP. If there was a piece of evidence that wasn't tested, you would in your PRP ask for that evidence to be tested. That's one of the limited pieces of discovery that you can get in a PRP is testing, forensic testing of evidence, but it's a big burden. It's not easy to get. So yeah, if you don't have evidence and there's limited discovery, you're expected to do that. And that's just a big procedural pitfall. That's another thing that a PRP facilitator could help a person with is just how to format a declaration, how to send a declaration to someone to sign so that it meets all the requirements of the Uniform Unsworn Statement Act. So PRP filing, when you file a PRP, there's the question of where do you file it? Well, you don't file it in the Superior Court, you file it in the Court of Appeals division where the judgment and sentence originated. So we've got 3 divisions of the Court of Appeals in the state. They each have a different geographic territory, and you would file it in the division where the case that's responsible for where the case originated from. So if a person got convicted of a crime in King County, but they're presently in Walla Walla serving their sentence, they wouldn't file it in Division 3, they'd file it in Division 1 because that's the county, that's the division that reviews judgments from King County, even though the person's not physically located there. I can tell you this though, if you file it in the wrong division, we'll get it transferred to the right division. The PRP is not going to get dismissed just because it was filed in the wrong location. We transfer them several times a year. It's a pretty regular occurrence. So that's not going to be something that's going to get you dismissed, but it will delay the case being heard. I mentioned already, failure to file the oath of verification will delay review. Failure to file the statement of finances will delay review. One thing, do not file the PRP in the state Supreme Court. The state Supreme Court, even if it's, have a good evening. The state Supreme Court, even if it's a successive PRP and the Court of Appeals arguably lacks jurisdiction to hear it, the Supreme Court will transfer it to the Court of Appeals. And I've had this happen where it's filed in the Supreme Court because the person knows that the Court of Appeals lacks jurisdiction. Supreme Court transfers it to the Court of Appeals. Court of Appeals takes a look at it. Court of Appeals says, yep, we don't have jurisdiction per in re restraint of Bell. Supreme Court, we are transferring it back to you. That is Rap 16.3C, saying that the state Supreme Court will transfer to the Court of Appeals. Court of Appeals does triage for the Supreme Court, and then we transfer it back to the Supreme Court if we're required to do so. That was something that changed in the early 2000s under Commissioner, I think that was under Commissioner Crooks's, no, after Commissioner Crooks's tenure. I think it was Commissioner Goff. Under his tenure, the Supreme Court was getting way too many PRPs for the number of commissioners and staff attorneys that they had. And so to reduce that burden, they started transferring more of those to the Court of Appeals right off the bat without any preliminary review. And then the Court of Appeals would triage them and send them back if they needed to be sent back. So if you file it in the Supreme Court, long-winded way of saying, it's just going to come back to the Court of Appeals. Just let the process play itself out. I'm sorry, it'll cause delay, but that's just how it works. Going back to 7.8 motions a little bit there. So I mentioned briefly that most 7.8 motions get transferred to the Court of Appeals and converted into PRPs. Sometimes people take exception to that and they try to appeal the transfer order. The transfer order is not actually appealable. If you think the Superior Court transferred the PRP in error and they should not have transferred it, what the petitioner needs to do is file a motion objecting to transfer. In a motion objecting to transfer, we routinely grant those at Division 3. I don't know about the other division, but Division 3, if we see something that's erroneously transferred, we raise it on our own motion all the time, because it's very important. We feel that if a person has picked a forum to hear their case, that it gets decided in the forum that they picked. So if they wanted it in Superior Court and it should have stayed in Superior Court, we will send it back to Superior Court unless it is obviously frivolous, which our state Supreme Court has told us, don't just send it back if it's obviously frivolous, keep it and get rid of it. So that's where to file it. I want to transition here talking a little bit about our internal procedures at the Court of Appeals and how these things get moved along behind the scenes. I mentioned a little, yeah.
Before we do that transfer, we have a question that's been going on in the chat. I want to make sure I get it right. Is that generally a person only has 1 year to file a PRP, right?
Mm-hmm.
And that would be from the judgment and sentence.
So there's three dates that we calculate that 1 year from, and that's RCW 10.73.090. And that gives you 3 dates. And that 1 year starts upon the last of 3 events. The last of the day the judgment and sentence was entered, the day that the Court of Appeals issues the mandate following an appeal, or the date that the United States Supreme Court denies certiorari. The very last of those to occur in time is what triggers the 1 year. There is an active debate. I have a slide on this later. I'll probably skip over it, but there's an active debate. Let's say the Court of Appeals remands for resentencing. That resentencing, the date that new judgment and sentence is entered, will be the date that the 1 year starts, not the date that the mandate is filed. So an amended judgment and sentence will be the date. But if the amended judgment and sentence is just fixing a typo, there's a date about whether or not just fixing a typo will start that 1 year, or whether or not the 1 year started when the mandate was filed. So there's a case that I cite in there a few slides down. Just be aware that there's an active debate that our Supreme Court is yet to weigh in on, but the Court of Appeals has weighed in on a few times about whether or not a ministerial correction to a judgment and sentence will start that 1 year. So if we get a PRP in, the first thing that we do is here at Division 3, this is something that's important for lawyers to know who practice in the other divisions. At Division 3, we have 2 staff attorneys, and then we have 2 court commissioners who are part-time staff attorneys. And when a PRP comes in, we rotate at different times of the calendar year who's the one doing the screening for the PRP. So that rotates around, and the staff attorney will look at that PRP within days of it coming in, and they'll triage it. They'll take a look. If it's Let's say it's a blank PRP and it's pretty obvious that the person is entitled to relief. We'll call for a response. We'll try and expedite the response. We'll try and do those things to speed it along. We'll decide whether or not we need to call for a response from the state or from DOC. If there's other documents that we need, so let's say a petitioner is raising an issue with their plea and they didn't include their guilty plea form, we'll call that up on our own. If it's a 7-8 transfer and the Superior Court didn't transfer to us the 7-8 pleadings, we'll call the Superior Court and we'll tell the Superior Court to send us those documents. And when I say we, I don't mean the staff attorney is the one calling the Superior Court, it's the clerk's office. The staff attorney is the lawyer for the clerk's office and advises the clerk's office, hey, could you go get those documents? And if we get those documents, we CC the petitioner on that. The petitioner will know that we're calling for documents usually. We check for formatting. So if there's a formatting, if you're a pro se, we overlook almost all formatting errors. If a lawyer filed it, we're less forgiving on formatting errors and we might tell them to fix it. So the staff attorney will be looking at those things and screening them and doing triage, usually within days of the PRP coming in. That doesn't mean that the decision will be out in days. The staff attorney will look at it. They'll then consult with the acting chief judge, who under the court rule is the person responsible for personal restraint petitions. They'll talk to the acting chief judge about it. Then the acting chief judge will make a decision, and the acting chief judge, depending upon what's on their plate, it might take a while to draft a decision and get that signed and out there. That's Division 3. The other divisions, Division 1 has one point person who does most of the PRP screening. Some of the other people there do it as well, but at Division 3, we have it spread across more people. Division 2, I think they spread it out across more people, across their staff attorneys. So that's a little bit different way of doing it at the other divisions. If we call for a response, we call for a response across the board if there's a DOC issue, because there's always records that we need from DOC on those. So if they have like if they're appealing an infraction, usually the person doesn't have all those records, and we call for a response from DOC because we need the records in order to adjudicate the issue on the merits. If there's records in the state's possession that would help resolve the issue, so say the person refers to records, but they don't have them and they're in the court file, we'll call for a response. And then finally, if the petition is not clearly frivolous, we call for a response. What clearly frivolous means, I don't know. I can tell you what frivolous means, but I can't tell you what clearly frivolous means. No court has ever defined that. So I'm sorry to the people who are non-lawyers. I'm getting really down into the weeds right now on this. If people wanted me to move out of the weeds, just let me know, but I'll keep going here. After we get the response to the petition, it moves to a different phase called the consideration phase. The consideration phase at Division 3, again, it goes to one of the 4 staff attorneys, not necessarily the staff attorney who was on screening. And one of 3 things will happen. The petition will either get dismissed as frivolous in consultation with the ACJ. The petition will get referred to a panel, which means that it starts acting like a normal appeal. There will be an opinion filed. Or if there's some glaring factual issue that needs to be resolved, we'll transfer it to the Superior Court for a reference hearing. That's where you start getting the limited right to discovery, is if we transfer to a reference hearing. And so if you need discovery, if there's evidence that you don't have and there's no other way to get it, a reference hearing is the way to do it. But I've got slides later on showing just how hard it is to get a reference hearing. It really is a Herculean effort.
Andrew, may I pop in with a question? This is Lila.
Please.
So on the last slide, you mentioned the screening for frivolousness. In Division 3, do you ever, or does the chief judge ever dismiss a subset of issues as frivolous and then pass the others to a panel? If so, what do you advise with respect to continuing to litigate those dismissed issues? If the court has bifurcated the case essentially and passed some of it on, but dismissed some of it, would you recommend that the person file a motion for discretionary review of the dismissed issues, even though only part of the petition has been decided? Is it even proper for the court to dismiss part of a petition as opposed to either passing the whole thing on or dismissing the whole thing? I'd just be interested to hear your views on that.
So I can tell you that I've had the same question myself when I first came back to the Court of Appeals. So when I finished law school, I came to Division III as a law clerk, and I worked mostly on direct appeals. I didn't really work on the PRPs. Left to be a prosecutor, was lucky enough to get hired back, and our outgoing senior staff attorney and commissioner, Jay Brahmi, he'd been here for 30 years, and he was our real guru on PRPs. He did a lot to help develop our practices here at Division III over the 30 years. And I was lucky enough to have a year and a half to work with him and try and absorb everything that I could from him before he retired. And this is something that's really unfortunate, is with the baby boomers retiring in short order, all three divisions of the Court of Appeals, we have had a real brain drain in our brain trust and institutional knowledge. A lot of that is gone. And I can tell you at Divisions 1 and 2, I think a lot more has been lost than at Division 3 because there's been less overlap with retiring staff than there was at Division 3. And I think that's sad. I can tell you what the practice has been historically at Division 3. In rare occasions, we have bifurcated a PRP where some of it has been dismissed and some of it has been referred to a panel. I can't tell you if that is proper or not. I can tell you that we've done it. The court rules don't clearly allow for it, and the court rules don't clearly exclude it. If you disagree, if you have a case where that happens and you disagree with that decision, I would encourage you to file a petition for review on the part that's dismissed right then and there, and then also proceed along with the appeal with the case as normal. If the court has bifurcated if Division 3 has bifurcated a PRP and we've dismissed some of the issues, continuing to argue them isn't going to help. The panel's just not going to address them. But if you have that happen, I would encourage you to file a petition for review. The Supreme Court Commissioner's Office, they'll take a look at it, they'll bounce it off the justices. And even though the decision will come from a commissioner, I can almost 100% guarantee you that commissioner has made their decision in consultation with at least some of the justices. And that would give a good idea. But I can tell you that for the most part, we don't do that. If we did do it, I can think of some reasons why we might do it. It might be because whoever is going to be working on that PRP downstream, we want to hone in on the issues for them, because the person who works for the PRP downstream is more often than not a law clerk, someone fresh out of law school, and it's not a staff attorney. And so if there's difficult procedural issues, we might just get rid of those and resolve those without the law clerk having to work with those, or to make the panels work easier. Or it might be if something has obvious merit and we want to streamline it, that might be a reason. I can't think of a time in the couple of years that I've been back here where it's happened. Doesn't mean that it hasn't happened. I don't see every PRP. As I said, there's 4 people who work on these in consultation with the acting chief judge. And so as senior staff attorney, my hands touch the majority of PRPs at Division 3, but not 100% of them. So there are things that the other staff attorneys do that I don't always see. So I can't say all the time that I know, but I know that this has come up. We've asked this, we've tussled about this, and it'd be nice to get some direction from our state Supreme Court at some point on that, to be frank with you.
Thank you.
So real quick on a reference hearing, these are the things, a brief overview of the rules for a reference hearing. If you are lucky enough to get a reference hearing, the Court of Appeals tries to issue a detailed order explaining the factual disputes that need to be resolved. We try and spoon feed these to the Superior Court so that they know crystal clearly what is expected of them and what they need to do. Because as I said, the Superior Courts, they don't have experience with this. They don't receive training on this. And so the more that we can corral them and guide them, the better the outcome is, the better the likelihood is that we get the information that we need, that the petitioner gets the facts that they need. So we try to be as detailed as possible in that order. The Court of Appeals may retain the PRP. So after the reference hearing is done, the Court of Appeals may say, okay, we're going to retain jurisdiction in the case, continuing jurisdiction. Or in our discretion, we can tell the Superior Court that they will retain the PRP and decide it on the merits. If you are a petitioner, you want the PRP retained in Superior Court for decision on the merits, and here's why. Once the Superior Court decides the petition on the merits, if that gets decided against you, you have the right to a direct appeal in all of the easier and more relaxed standards that come with a direct appeal. You absolutely want the Superior Court to retain your PRP because you want to have that possibility of a second direct appeal, and more importantly, indigent counsel as a matter of constitutional right. And because of that consideration, and because the Court of Appeals frankly wants people to have lawyers too, it makes our job easier. More often than not, we will direct the Superior Court to retain the PRP. We know that it's going to result in another appeal, which is sometimes more work for us, but it's usually in our interest and it's in the petitioner's interest. Written findings of fact by the judge are required. The hearing must be held. This is important. The hearing by court rule has to be held in front of a judge who has no prior involvement in the case. And we are very explicit in our orders that it needs to be a judge who had no involvement in the case. That's a requirement by the court rule. The evidence rules and confrontation apply. And by confrontation, I don't mean the Sixth Amendment right to confrontation. I mean the limited right to confrontation imposed by the Due Process Clause of the 14th Amendment. This is also important, and something that sometimes gets missed is when we order a reference hearing, prosecutors sometimes think that it's the petitioner's job to shepherd it along. No, by court rule, the prosecutor is required to be the person who makes sure it gets noted up for a hearing, gets set timely, gets resolved timely. The court rule actually places the onus on the prosecutor to make sure that the hearing happens. And then finally, the trial judge, or not the trial judge, the judge hearing the reference hearing can order discovery, but it's to their unfettered discretion. If we send it to a panel, we'll appoint counsel if RCW 10.73-150 allows counsel. If 1073-150 does not allow counsel, we generally don't allow counsel. If they have not had a lawyer previously and we're appointing a lawyer, we allow for supplemental briefs to be filed, but the supplemental briefing, it does have to comply with the time bar. And then after procedures, Supreme Court review. This is a little weird. If you're filing a petition for review to the Supreme Court, you follow two different sets of procedures. You follow the discretionary review procedures in RAP 13.5 A and C, but the criteria for getting the case reviewed is the criteria as if it was on direct appeal. That criteria mimics RAP 2.3 B, which is the same criteria for discretionary review at the Court of Appeals. So I'm going to get out of the weeds, get back to something here for the non-lawyers a little bit. And that's the time bar. So I mentioned that there is this big, huge time bar. You've got 1 year to file your PRP. And if you don't file that PRP within the 1 year, you can be in big trouble. That severely limits the number of issues that can be raised. If you don't file within that 1 year, you have to fit your issue within one of these 7 categories here on these slides. I'm not going to go into these 7 categories. I could do another CLE for 2 hours going over these slides, the exceptions to the time bar. But the big thing to know is that if you don't file within the 1 year, it doesn't mean that you can't file a PRP. If you are outside of that 1 year, you can still file a PRP, but the issues that you can raise are a lot more limited than if you were within that 1 year. If you were in that 1 year, you can raise almost any issue under the sun. And that's why it's so important to know when that 1 year deadline is so you can actually get your issues heard. So I mentioned that there's this 1 year time bar. There is also a 2 year time bar. This is where it gets confusing. So the 1 year time bar only applies if you are challenging a decision related to your trial or your judgment and sentence. If you are incarcerated and DOC imposes something on you that you disagree with, that's a different time bar. If you disagree with the DOC decision, there is a 2-year time bar that applies, and that's new case law. Previously, it wasn't clear that any time bar at all applied to DOC division decisions. We have now, through pretty rigorous advocacy for DOC over the last couple of years, the Court of Appeals has established that the 2-year civil catch-all time bar applies to DOC decisions. I can tell you that all 3 divisions of the Court of Appeals now have issued opinions. HEC is the only published, but the Division 2 and Division 3 also have unpublished opinions agreeing with HEC, and our state Supreme Court denied review of HEC. So as far as we're concerned, HEC is the law with regard to PRPs challenging DOC decisions. And so we've had it. We've had a PRP recently where a person was challenging a loss of good time from an infraction from a decade ago. They waited a decade to challenge the infraction. It's an unpublished opinion from Division 3. Division 3 followed HEC and said, it's time barred. All that we will do is we will review infractions from within the last 2 years. We're not going to go back a decade and look at infractions from a decade ago. So those are the 2 time bars that apply. Now, there are exceptions, and here is a ray of hope. For most of our state's history, getting an exception to the time bar. So I mentioned that there's exceptions to the time bar, but there's also a way to expand the time bar to make that 1-year clock or that 2-year clock run a little bit longer. And the way to make that clock run a little bit longer is what we call equitable tolling. And through most of our state's history, equitable tolling was nearly insurmountable. It was almost impossible to get equitable tolling. Earlier this fall, this summer, our state Supreme Court broadened equitable tolling. There is now a way to get equitable tolling under this Fowler standard, which is a lot easier to prove. It's still hard to prove, but you can expand that by showing that you have diligently pursued your rights, not an extraordinary circumstance prevented a timely filing. So in Fowler, what happened was the person hired a lawyer. They actually gave money to a lawyer to file a PRP. The lawyer did what no lawyer should ever do. They took the money and ran. They didn't file a PRP. They didn't work on the case. They just took the money, pocketed it, and then they stopped responding to letters. They never filed a PRP. They didn't do anything. Our state Supreme Court said that when a lawyer takes the money and runs, that is an extraordinary circumstance that justifies a person having an extended 1-year time bar, because it's not that person's fault that they missed the 1 year. It was that crooked lawyer. The next question is for all of you folks, aside from the extreme circumstance of a crooked lawyer taking the money and running, what else would justify an extraordinary circumstance preventing a timely filing? I don't know. One of the things that we've been wondering about is whether or not, let's say you file a Public Records Act request to get evidence, and you need that evidence to file your PRP, and the state is dilatory in responding to your PRP request. Is that an extraordinary circumstance? Maybe. It's something we've been wondering about. We haven't seen it yet, but I could see that coming up. If you file a Padgett motion to get your client file and you get jerked around on getting an access to your client file, is that an extraordinary circumstance that prevented timely filing? Possibly. I don't know yet. We haven't seen it yet, but these are things that we've been wondering about. So food for thought. We don't know what else is going to qualify for relief under Fowler, but it's up to you folks to make those motions. So time bar, those are the time bar. I've really flown through that. I can't stress enough how important it is to know the time bar and understand the time bar. And this is why it's so important that people have a right to counsel, because it's so crazy complex. It's just so ridiculously complex. And I'm going to add another layer of complexity to it right now. And that's mixed petitions. So a mixed petition, someone misses their 1 year. They file a PRP after the 1 year. If you file a PRP after the 1 year, all of the issues, so let's say you have 5 issues that you want to raise, all 5 of those issues have to fit within one of these 7 categories. If any one of your issues, just one of those issues, doesn't fit within one of these 7 categories, your whole petition is dismissed. It's dumped, it's tossed. So your other 6 issues that would otherwise be considered timely, the court doesn't hear a single one of them just because one of them was untimely. The reason for that is a quirk in the way that RCW 10.73.100 is worded, and that's because of the word solely in that statute. If your PRP, if all 5 of your issues aren't solely exempt from the time bar, the whole petition is dismissed. It's a really harsh rule. Now, people, if they have arguments that get dismissed, let's say 4 of those issues would be timely, they can come back, they can file a new personal restraint petition raising only those 4 issues. And because those 4 issues fit within one of these 7 exceptions, the court will then hear the case, but it delays them. It delays them months and months and months. And that assumes they even get to know what of their 5 issues was untimely, because the Court of Appeals isn't supposed to tell them which issue was untimely. Yeah. I see people there who are just shaking their heads going, that's nuts, but that's the rule. Sometimes we'll tell them what issue was untimely and we give them direction, but it's a pretty hard rule. And then here's another exception to it. So if your case doesn't fit, if all 5 of your issues don't fit within all these 7 categories, we'll dismiss the petition. Except for one category. There's one category that we will review no matter what, and that's a facial invalidity claim under RCW 10.73.090. So for the lawyers out there, the mixed petition rule only applies most of the time. This has been a weird one. This was I'm wrapping my head around, and I can tell you the state Supreme Court, I'll fess up here. The state Supreme Court called me out on this. Well, called our ACJ out on this, but it was at my bad advice to our ACJ. One of the early PRPs that I worked on, it was mixed. And I said, Judge, it's mixed. We're going to have to dismiss it. And so he dismissed it. This is how I learned about this 10.73.090, because like judges where they don't receive training on this, we receive limited training on this. The person petitioned for review. And one of the things that I do for quality control is anytime that a person petitions for review, I actually check and take a look at it, because our Supreme Court commissioners are wonderful. Our state Supreme Court commissioners will issue detailed rulings, and I take a look at those rulings, and our state Supreme Court deputy commissioner who reviewed the case said, Court of Appeals, ACJ, you got bad advice. We will actually review 1073.090 claims, even in a mixed petition. So in a mixed petition, we won't review any of the claims. We'll dismiss the whole petition, but we'll still review the merits of an 090 claim. So I got corrected on that. I now know that, but that's one of the things that happens when I mentioned that the other divisions in Division 3, we lost our brain trust. We lost our institutional knowledge. These are the things that we miss. These are the errors that occur when you lose your institutional knowledge. I made a mistake. I just told you folks about it. I learned from that mistake. And our chief judge learned from that mistake, and we're learning from that. But I'm going to tell you, there's a chance that we're not error-free. We are not all-knowing. We are not all-powerful. We are not infallible. We do make mistakes. And I'm here to tell you that we do make mistakes. Just as superior courts make mistakes, we make them. So people also need to know you have the right to seek review and petition for review at our state Supreme Court. We try as hard as possible to be as thorough as possible and not make mistakes, but it happens. That's why we have a Supreme Court, is to keep a check on the Court of Appeals and the trial courts. One of the many reasons we have a Supreme Court. If the state Supreme Court loses their institutional knowledge and they don't have good transition, God help us. Thankfully, our state Supreme Court has done a very good job. When their staff attorneys and commissioners have retired, they've cultivated institutional knowledge, they've brought people up, they've been able to maintain that. And so thankfully, our state Supreme Court has been really good about that. But with baby boomers retiring, this has been a problem. And I worry Our state Supreme Court, you look at who their commissioners are and you look at how gray their hair is. I worry whoever takes over after them and the justices that are currently there who are graying and may come in after them don't know this. We might be in a situation where our state Supreme Court doesn't keep this institutional knowledge. And they might not know about all these rules. And they might misapply these rules. And it's important for lawyers to know these rules also so that they can call out the justices, call out the Supreme Court, call out the Court of Appeals, file their motions for reconsideration, file their motions for discretionary review. Because with the baby boomers retiring and us getting new blood in at all court levels, this is a very dangerous and unsettled time for people and for courts where we are losing that institutional knowledge. That transition has already happened at Division 3. We're building it back up, but the Supreme Court, we're on dangerous ground in the next few years.
Hey, Andrew.
Yeah.
2 issues. Number one, I think we got about 10 minutes left.
Okay.
Right? Until about 7 o'clock. And then the other thing is that someone had a question in the chat about, and I'm not sure you can answer this question, but how did the mistake you made play out for the petitioner, if you know, or if you can say?
I don't mind talking about it because that case is final. It's finalized. Everything that happened in it is a matter of public record. The mistake that I made is a matter of public record. The fact that I'm the person who made that mistake is not a matter of public record until now. I'm on camera admitting to it and fessing up that I gave our court bad advice in that case. What happened is our state Supreme Court, they took a look at it. They then addressed the 1073-090 claim, the facial invalidity claim on the merits, and they resolved it on the merits. So the person, their claim still got heard. But it only got heard because that person filed a petition for review. If they hadn't filed a petition for review, it wouldn't have gotten heard at all. And that mistake that was done by the court, that would have been an injustice. And that was a learning experience for me. That was happened early on when I came here. And that is not a mistake I want to make. As I said, I review the state Supreme Court's commissioners' rulings. I review all these things regularly. I review all the new case law. Every single PRP decision, every single criminal decision that comes out, published, unpublished, I read it. I read them all religiously. We've done a lot of work to institute quality controls here to help deal with our loss of institutional knowledge. We do regular updates. Our state Supreme Court does an annual PRP CLE for all 3 divisions of the Court of Appeals. So we've been working hard on quality control here, but I can tell you mistakes happen and they do get made. And every time that happens, it's an injustice. And we try hard not to have it happen, but it does happen. So, all right, done falling on my sword for the moment. I want to go ahead here and I'm going to skip a few things, quite a bit of things. I want to talk about prisoners' rights because this is so important for pro ses because prisoners, they almost never have a right to a lawyer. They almost never receive a lawyer. And so for those of you who are going out to communities and talking to communities about doing these things on their own, I think it's important that they have a little bit of knowledge of these standards because they're not going to get it from a lawyer. So if you have a person who's challenging a DOC decision, so they're not challenging their conviction, their judgment and sentence, they're challenging a prison infraction or a credit calculation or something like that, there are much more generous standards that apply. If they have no previous or alternative avenue for obtaining state judicial review, all that they have to show is that their restraint is unlawful. They don't have to show prejudice. All that they have to show is a violation of law. No prejudice whatsoever. It doesn't matter if the violation of law was a harmless error, they still get a redo. And that's the Cashaw standard. That's important for people to know, is if DOC screws up, they get a redo, they get a new hearing, they don't need to show prejudice. Prison infractions, they need to know the Washington State Administrative Code and they need to know that the Administrative Code applies to prison infractions. This is where it's really rough though. Although a prejudice standard doesn't apply if they're challenging the sufficiency of the evidence for an infraction, all that needs to be shown is that there is some evidence in the record to support the disciplinary infraction. They don't need to show a preponderance of the evidence, clear and convincing evidence, proof beyond a reasonable doubt. It's just some evidence. It's basically probable cause. Basically, it's highly deferential to DOC. We don't reassess weight. We don't reassess credibility. It's rough. So that's prison infractions real briefly. You don't have to show prejudice, but if you're challenging the sufficiency of the evidence, you're pretty much toast. I hate to say it. Procedural challenges to prison infractions. Here's one that I think is important for prisoners to know. Let's say that they're not challenging the sufficiency of the evidence, but they're saying that they didn't get a fair hearing by DOC. DOC didn't give them a fair hearing. They just have to show that it was arbitrary and capricious. But if they don't get the minimum constitutional due process, then they're out of luck. So it's very important that they know that their due process rights is due process of the 14th Amendment and the case law interpreting due process of the 14th Amendment of the United States Constitution. That's the procedural rights that apply. Their 6th Amendment constitutional rights, they think that they have a right to confront and cross-examine witnesses like under the 6th Amendment. Unfortunately, they do not. It's a very limited right under the 14th Amendment. Another thing to know, and this is something for the lawyers to know if they ever get a case, WAC 137-28-140, the following rules set forth procedural guidelines. They do not create any procedural or substantive rights in any person, including any liberty interests. So this is really interesting. I mentioned that prison infractions are governed by the WAC 137-28, except 137-28 is just a big old disclaimer exception that swallows all the rules saying, here are all the rules that apply to infractions, but they don't actually apply to DOC. If we don't want to follow the rules, we don't have to. Only the petitioner, only the inmate has to follow these rules. It's very one-sided. In Kozel versus DOC, it's a per curiam opinion from our state Supreme Court. I think they cast a little bit of doubt on the validity of this WAC, but it's just something to know about. The WACs for prison infractions are very one-sided. So for example, there's a section of 137.28 that says that DOC has to give you at least 24 hours notice of your hearing. If DOC doesn't give you 24 hours notice, let's say they give you 12 hours notice of your hearing. Under this WAC, that's okay. Never mind, there's another WAC that says they have to give you 24 hours. This WAC says it's okay that they gave you 12 hours. Naturally, that raises some due process questions. And that's a latent issue, let to be litigated. TBD, if you raise that issue in the future, I'll be curious to see what happens. Other things to know, hearsay, absolutely admissible. The rules of evidence do not apply, but as a matter of due process, hearsay must still be reliable. And then also WACs for community custody violations and prison doses. That's prison disciplinary proceedings, flown through really fast. I just wanted to talk about that real briefly. PRP of Williams. This is something that people who are presently incarcerated absolutely need to know about from our state Supreme Court earlier this year. This is a huge, huge opinion from our state Supreme Court saying that our state constitution's version of the 8th Amendment is more protective of prisoners' rights than the 8th Amendment. So if their conditions of confinement are atrocious, let's say they're not getting medical care. Let's say that in the instance of Williams, they don't have access to bathrooms. They don't have access to running water. Possibly they don't have a diet. Let's say that they have a really bad autoimmune disease that prevents them from having gluten or prevents them from having high fiber, and they need a low fiber diet, and they're being deprived that. Williams opens the door for them to raise that in a PRP. Previously, to raise those claims, you would have to show that the prison ignored their claims with deliberate indifference. Deliberate indifference is no longer the standard. If the prison just doesn't care, benign neglect, they just miss it, it gets lost on someone's desk that this person needs a special diet. Under Williams, the chances are very high now that they will get relief, where in prior years, decades, centuries, they would get no relief at all. So it's really important that inmates know that if they
And need food.
if their health is at risk, they have unhygienic conditions, they have cruel conditions, they have new support that they didn't have before.
Oh, no, I haven't. I've just been out in the shed.
So just to recap here, tidying it up at the end, we covered some internal court procedures. We covered statutes of limitations and tolling, covered the time bar exceptions and mixed petitions. We didn't cover 4, 5, 6, and 7. I'm sorry about that. I talked way too much. Covered briefly 8 and 9. So, but you will have access to the slides